Now we're in front of the Broward County Judicial Complex. On July 16, 2007, after our second attorney, Paul Golis, was disbarred and we did a written press release for help, we were contacted by Mary Stevens, the assistant to Schutz and Bone attorneys Alan Rubin Esquire and Suzanne Driscoll Esquire, to discuss representation in our eminent domain case. Meeting with them 2 days later, they thought we had a really strong case and that many more things were illegal in all the previous proceedings than even we knew ourselves, and offered to represent us. After a judge ruled that the CRA does not have the power of eminent domain and cannot legally seize property, our Schutz and Bone attorneys thought the best approach would be to vacate the order of taking, which would give us our property back and open the door to initiate a separate action to reclaim damages due us, including business damages for the illegal taking of our property in the first place. They also said that if they were unsuccessful, they would represent us in the eminent domain proceedings and trial, and that the fees would be billed to the CRA. We paid them our last $10,000 as a retainer to vacate the order of taking. We later learned that in eminent domain proceedings, the general idea is that the condemning authority, the CRA, is supposed to pay for the legal fees of the defense, including attorneys and experts, with the idea that private citizens may not be able to mount a defense against the government, and with the concern that eminent domain by the government needs to be exercised very cautiously, and that the private entity needs to be protected, so government is not allowed to trample individual rights. This sounds great in fantasy, but in reality, you have no rights, and the condemning authority tries to bury you from the very beginning. The 4th District Court of Appeals denies our appeal to have an evidentiary hearing on our motion to vacate the order of taking. So we are denied due process to state our case and to bring to light all the illegal practices by the City of Pompano Beach CRA and its representatives. Upon losing our appeal, our Schutz and Bone attorneys tell us we owe them $100,000 for the appeal and that the funds will come out of our future settlement. A few weeks later, they tell us that we owe them $167,000 for the appeal, with no explanation where the extra $67,000 came from, and saying that to do discovery and go to trial for the eminent domain case itself will cost between $40,000 and $70,000. We spent almost a year prepping for our eminent domain trial, working with experts and trying to mediate with the city to no avail, closely working on our legal case with Suzanne Driscoll, who we were told was our trial expert, never seeing attorney Alan Rubin except on the day we tried to mediate with the city. Part of our developed plan was to have Dr. Erickson testify to value, as he is a real estate expert and the person who funded the entire project, having workers at the building every day for 3.5 years, much of the work extremely expensive and mandated by the City of Pompano Beach. They made us fix it up and they made us spend all the money. On the Friday before trial, we go to the Schutz and Bone office for final trial prep, and they inform us that they are no longer interested in representing us and that they are not going to trial. This right after we received a letter saying they are ready for trial and that Alan is going to trial with us this time, as he was not present for pre-trial motions in December 2009. At this time, Suzanne Driscoll tells us that they should have filed for a change of venue, that we cannot get a fair trial in Broward County, and that Mitch Bernstein, the attorney for the CRA, has the judge in his back pocket. To have the judge at the pretrial motions removed, as it seems to us that he was working with only the city's interests in mind, which is contrary to eminent domain law, where rulings are supposed to err on the side of the person who is losing their property and not the government trying to take it. So on the Friday before trial, they said they are voluntarily withdrawing from the case, that all eminent domain cases are a risk, and they don't think that this one is going to pay off, so they were going to cut their losses. With the idea of a voluntary withdrawal, it is generally thought that the attorney waives its rights to fees, as they have stopped an award from being possible in the first place. We received a phone call later that day saying that we needed to appear at trial on Monday morning, March 1st at 9:15 a.m. without any clarification, as they had just fired us. We showed up to court early Monday morning, hoping to get some clarification of what is going on, and 2 minutes before the judge walks in, our attorneys show up and ask if we'd like to speak to them. We say yes, thinking they changed their minds and we're going to trial, and they inform us that there's an offer on the table to receive an additional $90,000, and they will pay our experts and keep the rest. They think we should take it even though nothing is written down. They say we owe them $300,000 in fees, which is $167,000 for the appeal, which, if you remember, is $67,000 more than they told us in the first place that the bill was going to be, and $133,000 for trial prep, which is $63,000 more than the trial was supposed to cost after its completion. And we have not had a trial yet, which we were informed would cost another $120,000. If they took us to trial, the bill would be $183,000 more than they told us after they lost the appeal, and if you add in the additional funds we owe for the appeal, then we would owe them $250,000 more than they quoted. There is something really wrong with this. The judge gave us time to discuss the offer, which made no sense to us as we spent $2.5 million on the building, and when the judge returned, Alan Rubin from Schutz & Bowen asked if we were going to take the deal. We said no, and he said that then they are withdrawing from the case. They argued to the judge that our case has no merit, and they were withdrawing, but failed to mention that they thought it had enough merit to bill us $300,000 in legal fees, of which we've never received a bill, but now the case doesn't have any merit. I don't really know how that is possible, but nothing in this case follows the law. We have been irreparably damaged by our attorneys, who have filed a charging lien against our file, even though they voluntarily withdrew and told us they were cutting their losses, and that they have damaged our ability to get new counsel because of their behavior. To make matters worse, I tried to appeal to Alan Rubin of Schutz & Bowen to see if there was a way to settle the case, and was specifically told that there was no way to settle with them, and that Schutz & Bowen was prepared to walk away from this case totally, and that they would make sure that we didn't get another penny. So this is where we are. Corrupt government, unethical commissioners, and from our perspective, unethical attorneys on both sides of the playing field. 5 years later, no attorney, still no trial, and obstruction of justice is rampant. Due process is not available in the eminent domain realm in South Florida, and we need your help. This is a grassroots campaign to stop the injustice and corruption and make us whole, as it states in eminent domain law. We are supposed to come out in as good as or better financial condition than we were in before our property was taken. That is what the law says, but so far in this case, the law has never been followed. Help us hold our government responsible. This is important for all of us as citizens, in that the Constitution is only as good as we all cooperate to uphold it. Thanks for watching.